This channel does not promote any violent, harmful, or illegal activities. All content provided by this channel is meant for an educational purpose only.
Well, at 9, I am for the petitioner.
Yes.
Well, at that matter with regard to, my lord, the public prosecutor and, my lord, his daughter being there in the same litigation. My lord, your lordship will kindly recollect, my lord, on the last occasion when your lordship took up the matter, Mr. Bhattacharya raised an issue with regard to suppression of a particular order being passed in the trial court.
Yes.
My lord, if that order is with your lordship's
Yes,
not
it
a
is.
part of the records, it's an order of 4th of April 2025. Now, my lord, kindly see the second paragraph of that order which records. My lord, has that order, my lord?
Yes, yes.
Kindly see, it records, today is fixed for hearing petition dated 26th of March 2025 filed by the accused persons. My lord, this entire order is passed on the basis of this petition. My lord, I've taken out the certified copy. Kindly have a look at this petition. Kindly see the nature of this petition. My lord, in this petition, my lord, subject to correction by your lordship, firstly, my lord, there was no prayer made to change the learned public prosecutor. On the contrary, my lord, what was sought to be put on record is the conduct of the learned public prosecutor, particularly with regard to what is said in paragraph 3, that a 161 statement was changed during the course of trial, and that was brought to the notice of the court, the trial court. Now, my lord, the reason why, my lord, I have taken instructions, my lord, as a now officer of your lordship's court, I would say, my lord, that this order should have been disclosed. But, my lord, kindly see and kindly visualize whether the learned trial judge, firstly, my lord, no prayer was made for the learned change of the learned public prosecutor. Secondly, my lord, the learned trial judge doesn't even have any power to change the learned public prosecutor. My lord, just to give an example, my lord, on a lighter note, my lord, if I take out a 226 petition before a district judge and the district judge says, sorry, I have no power, so rejected, do I need to challenge that order of the district judge before this honorable court, my lord? I am asking myself. So, my lord, this, and if your lordship sees this order, everything is recorded, including the fact that the learned public prosecutor and the counsel for the de facto complainant who was representing up till a particular stage, everything is admitted, my lord, in the last paragraph of the first page of the order of 4th of April. But, my lord, this order, my lord, subject to correction by your lordship, we cannot, there is nothing wrong with this order to the extent that firstly, there was no prayer for change of public prosecutor, which is my specific prayer before this honorable court. And it is your lordship who is only entitled to do that. The sessions judge could not have done that, and hence I could not have revised that order.
Listen, if A appears or B appears, it hardly matters to you. But he is alleging that he is not facing a proper trial.
My lord,
And this order
certainly
also
matters to
discloses
me
that.
because
Why?
after all, 13 witnesses have already adduced evidence at
But
the stage of trial.
sir,
And my lord, the
What
learned
is going
public
back?
My
prosecutor.
lord, one more thing I wanted to tell your lordships, my lord. If I had such an intent of suppressing and things like that, my lord, on day one when he applied for addition of party, I didn't oppose it. Otherwise, I would have opposed him tooth and nail, my lord.
Well, it
sir,
is specifically,
thing is-
lordship sees, the learned judge specifically records the wakalatnama filed on behalf of the de facto complainant during the investigation stage.
Huh.
Now, my lord, she had filed her wakalatnama in investigation stage. Thereafter, before the trial court, that is the sessions court, a fresh wakalatnama was filed on behalf of fresh set of advocates. That is also there on record.
Is
were not-
Tapon and Sunita no longer there?
No, she had filed
Chopon is
her.
there.
My lord, she had.
Yes.
Sunita had filed her
Chopon is
wakalatnama
there.
at the investigation stage on behalf of the de facto complainant in the before the court of the learned magistrate. Now, before the sessions court, after it was committed,
Amar copy.
my lord, Mr. A.H. Biswas and Aurobindo Mitra had filed a fresh wakalatnama, which is also on record, and this is way back on 25th August 2020. My lord, this is the
I
wakalatnama
do not
certified.
wish to, my lord, kindly considers this, my lord. I
the
do not
certified
wish to
copy
make
which we have
comments
obtained from the
with
trial
regard
court
to, my lord,
records.
discretions of learned advocates in their professional capacities, my lord.
I do not understand if there is a request for change. How is it troubling you? And why is
a
it
de facto-
troubling you?
Well, certainly, because my son was brutally murdered.
Hmm.
But it
I'm
was a
not
case of
saying-
contract killing by the petitioner.
Not praying
I
for
am
discharge.
the victim's father. right from the very outset of this case, Mr. Chakraborty, the learned senior public prosecutor, had been dealing with the case. 13 witnesses examined the complaint. He is absolutely conversant all along with the case. This issue of change of public prosecutor could have been raised immediately at the time of framing of charge, or in 2020 when Mr. Chakraborty was appointed.
Yes, that was because the daughter and the father.
No, my lord, Mr. Chakraborty, learned special public prosecutor, was appointed in 2020. His daughter was appearing for the de facto complainant in 2019. From 2020, a fresh set of advocates is appearing on behalf of the de facto complainant. This is the certified copy of the Wakalatnama.
Page 28 of my application.
All right, you tell me one thing.
Lordships.
The de facto complainant,
Lordships.
right, and the PP, they lie on the same plane.
Subject
One
subject
supporting
to
the other.
Milord, subject to correction by your lordship, Milord. The law is settled by the Honorable Supreme Court. I have brought those judgments. Milord, the Supreme Court clearly says that the office of the public prosecutor stands on a completely different pedestal. The reason is, Milord, the reason is Mr. Dev's client allegedly is the victim, rightly or wrongly. Mr. Dev's client has lost someone and he is alleging that to me. So Mr. Dev's client and his legal team, their single point objective would be, and maybe rightly so, that I am convicted. The public prosecutor's role is not to secure a conviction. The public prosecutor has to be dispassionate. The public prosecutor has to only uphold the interests of justice.
A neutral person.
Absolutely.
I believe
so the learned public prosecutor,
the
learned public prosecutor, আমি কোর্টের একটা query respond করছি. Well, therefore, my lord, the law requires.
Where is the state?
And the Honorable Supreme Court says.
Lordship, I'm led by Mr. Tapan Kumar Mukherjee. He's on legs in court number 4.
Mr. Mukherjee's stance was that if the court desires, he can take steps with the LR and the
right. Where is it?
Lordship,
you have written instructions.
Lordship, on the last occasion,
and someone from the panel can be appointed.
Report, Lordship.
Did
the instruction. Yes, Lordship. 15th May 2025.
I don't see anything on record. 15th of May.
Yes, Lordship.
Yes, photocopy. Photocopy of the prayer of the accused. This one page, 15th of May.
Lordship.
No, it is not that.
It is just a reference to the.
Yes, nothing is mentioned over here.
And Milord, indeed,
the
learned trial court has recorded that for a same witness, there are 2161. One different copy of the same witness has been supplied to us in terms of 207. When we go to cross-examine, the public prosecutor confronts that witness with another set of 161. Everything comes out in the order sheets, Milord. I do not want to open, Milord, that Pandora's box. Because it relates to, Milord, learned advocates.
These are allegations which have never been substantiated.
I have taken those points.
Will it be very fair if these type of allegations are to be substantiated against a professional who is your fellow colleague?
Absolutely.
It will not be nice.
He is a senior prosecutor in the Alipur.
Whoever it is.
I do not think my learned friend is referring
speaking for myself, Milord,
against the learned public.
Speaking for myself, Milord, if I was in the shoes of that.
It's somebody who is no way connected with the de facto. Be engaged. It is
my lord, since 2019, the public prosecutor was appointed in 2020.
And one thing, as counsel brief, you get briefs at the hearing stage. It is not necessary at the motion stage you will be briefed. If somebody else comes in, all documents will be there.
My lord,
where is
I bow down before your lordship. But in this case, the de facto complainant was appearing in 2019.
Yes.
She resigned from the brief in 2019 and a new set of advocates representing the de facto complaint appeared in 2020.
But then, there should not be any hunch in the mind of the accused person that he has not been provided with a fair opportunity of trial.
I think nobody is disputing the neutrality of the public prosecutor.
He is.
But then let the legal remembrance take a call.
Yes. This is what his prayer is. He doesn't want anything more. And the court is not appointing anybody.
Let the legal remembrance decide the issue neutrally. Well, I believe
that after all the entire exercise, let the legal remembrance decide whom to appoint.
whether to also
Instead
remove the
instead of
current
the
public
incumbent public
But
prosecutor.
submission made on behalf of all the parties. What is your name?
Lordship, my name is Mona Lisa Maiti.
Where is the recorded on record of the state?
Lordship, both are engaged in court number 4 and 18.
Then none of the names will be recorded. Mind it.
Lordship.
আচ্ছা কি বললাম made on behalf of parties stuff. The petitioner has submitted that the public prosecutor who is handling the
Trial.
Sessions trial.
case pending before the learned additional sessions judge, 10th court, Alipur, in ST number 01 within bracket 11 22 11 টাই শুধু ব্র্যাকেটে আছে স্পেস আর number 61 of 2020 is acting more on the behalf of the de facto complainant. Stop. The petitioner submits that the public prosecutor should take a neutral stand and not take side of the de facto complainant. Stop. Initially, the de facto complainant was represented by the daughter of the public prosecutor. Stop. Prayer has been made to change the public prosecutor. Stop. The prayer of the petitioner is opposed by the learned advocate representing the applicant / de facto complainant. Stop. Next. As all is entitled to a fair trial, none should reel under the misconception that a proper trial was not allowed to a litigant. Stop. Only for upholding the interest of the trial and for maintaining its sanctity, the court is of the opinion that the legal remembrancer should take a call with the request of the petitioner for change of the public prosecutor. Stop. The legal remembrancer is directed to engage any other public prosecutor or special public prosecutor to handle the case from the list of the public prosecutors / public prosecutors maintained by the state of West Bengal. Stop. Decision shall be taken by the by the legal remembrancer at the earliest, but positively within a period of 2 weeks from the date of communication of this order. Writ petition.
Lordship, I am for the state, Lordship.
Take this. What is the use after coming out when the order is disposed?
Lordship, I was engaged in part 4, Lordship.